Hey folks, Greg Siskind here for the weekly live stream from Siskind Susser. It has been a couple of weeks where we were on hiatus because it just happened that New Year's Eve and Christmas Eve both fell on Wednesday nights. So we decided to take those two off, and we're back. And not that this is that's usually a slow news week. It certainly wasn't for immigration. But there's certainly plenty to report over the what's been happening in the last week or so. So I have a lot of things I'm going to be talking about tonight. I'm just by myself, so there won't be the banter back and forth that we usually get when there's a couple of us here talking about it. But I will give you my take on various stories. So the big one is it's Elisa Tab always says that sort of like the big news usually happens right as we're preparing for this weekly show. And that is definitely true. I wasn't really sure sort of like what the right way to caption today's news, but I think it's just better to refer to this story by the name of the young woman, 37-year-old woman that died today in what ICE was celebrating early in the day as the biggest ICE action in the country's history, with more than 2,000 agents that were sent up to Minneapolis and were conducting actions all over the city. There was a woman that was an ICE watcher, and basically what these folks do admirably, in my opinion, is to document what ICE is doing so that the public is informed about what's happening, and to make sure that neighborhoods know what's happening with ICE conducting operations in the city. And so most of you probably have been watching the news or heard about the news already, that there was an incident where this woman, Renee Good, was in her car, was being approached by ICE agents who were attempting to enter her car. She tried to drive away. One of the officers shot her 3 times, and she died right after that. There are several things that happened right away. One is that Kristi Noem, the Secretary of Homeland Security, without any information essentially on what really happened, immediately went out and said that this woman was a domestic terrorist who was rioting and was attacking ICE officers. And of course, one of the things that empowers the public is the fact that there are so many citizen journalists out there who are filming everything, and that's good in the case of immigration enforcement, where there's some accountability because there's actual video, and that happened today. There have been 3 different videos showing the whole incident from beginning to end. And it is pretty apparent in my view, but also after listening to a lot of forensic analysts that have been on the media, as well as some of the experts in the the experts both in the broadcast and print media that have been interviewed, that it appears that that the ICE officer is not going to be able to claim self-defense, and that there's going to be an investigation. In the case of this woman who is a U.S. citizen, she her husband died 2 years ago, and she had a 6-year-old child who's now an orphan. It's just a horrible story, and there are protests happening right now, big protests happening in Minneapolis, but I understand in other cities they've already started. I hope this doesn't turn violent like we saw after George Floyd, where there were there were a lot of peaceful protests after that, but also there were further there was further violence, and I think the mayor of Minneapolis and the governor of Minnesota were both pretty vocal today in saying that it's really important that protests stay peaceful, um, and that they are not used as a pretext for invoking the Insurrection Act or doing other things that I'm sure the administration would love to use today's the reaction to today's news in a way that um, would give them the excuse to be able to do those kinds of activities. So we will wait and see on that, what happens, but it's been pretty depressing, particularly if you've seen the video, the what happened today. So I'm going to leave it there on that. There's not really that much to talk about in terms of immigration uh, policy, other than what I've said numerous times in the past on this broadcast, which is that when you have ICE acting as basically a paramilitary organization, wearing masks and not really being, observing the norms of law enforcement, um, you expect things like this to happen. And I would hope that this would be a time maybe for a pivot where they try and take more of a professional view of their job, but I'm not holding my breath. Anyway, moving on, there are a couple other things that I wanted to mention. One was well, actually several things. I think I got about 10 things. There was a Politico story this week that had reported that there have been now more than 300 judges that have basically ruled against the Trump administration regarding its detention policy, and have allowed people to bond out. That's it's a 1,600 cases, I think, so far, and I think something that's noteworthy is it's judges that have been appointed by every president since Ronald Reagan, including Trump. So that was an interesting news item that just came out. A lot of people are paying attention to the 39 country travel ban. I wanted to mention that case, that news, because there's several things that are flowing from it. One is that the travel ban itself on 39 countries, we've talked about that went effective for the expanded list on January 1st. And that itself is, I think people were prepared for. I think what was a surprise was that the administration started extending the travel ban to domestic immigration processing with USCIS, which is something new. And basically what they did was they issued a memo saying that they are pausing all benefits adjudications for people from the 39 countries based on the travel ban itself, and that they are going to be basically reviewing their vetting policies. They don't actually they don't actually provide any timelines as far as how long this is going to last, and I'll tell you who it affects. I mean, it's a pretty broad group. It's basically non-immigrant change of status applications or adjudications for things that require consular processing abroad, naturalization applications, green card applications, J-1 waiver applications, temporary protected status, asylum, pretty much across the board. If you're from one of those countries, you're impacted by it. Interestingly, it doesn't track in an identical way with the actual travel ban. For example, and with this one, I went into some length talking to some impacted people today. But if you are a dual national and one of your countries of citizenship is not in the travel ban, if you enter the United States with the passport that is not the travel ban country's passport, then you're not impacted by the 39 country travel ban according to the proclamation. USCIS is taking a different view, a more restrictive view, and saying it doesn't matter if you have dual citizenship. They're only looking at the country you were born in. They make some reference as well to people who acquire second citizenships by investment. But the way I am reading it is that the dual citizenship exemption that applies when it comes to the travel ban is not doesn't apply to the benefits pause in the same way. What's going to happen with that? Well, I will tell you that there are already 2 lawsuits that have been filed. One is the Akmurat O'Doe versus Trump case in Massachusetts, filed by my friend Jim Hacking. And then Curtis Morrison, another friend of mine, has filed a case in San Francisco. And I'm happy to report that Impact Litigation is preparing its own case, which will have hundreds of plaintiffs in it. We are filing it. We're anticipating filing this case on Friday. I can't really give you details about where or any of the legal arguments or anything like that yet, but we'll have more to report on that next week. So look for that to be happening. But that's that being said, there's a lot of questions in the litigation. If a judge will a judge just apply it to the plaintiffs in the case, or will they take down the whole policy? What is the Trump administration's reaction going to be if and when that happens? There's a lot of unknowns at this point. So, immigration lawyers have been advising people, if this happens, then this might be the right strategy. If this happens, this might be the right strategy. But right now, there's just a lot of unknowns. And one thing I can tell you is you can file applications. The pause is not on accepting applications. The pause is on adjudicating applications. So we will, in some cases, filing the application is really important. There are some exceptions of types of applications that are not covered. For example, I-90s, that's to basically, if you have an expiring green card, you can still file and get that kind of application adjudicated. But most of them are not being adjudicated. Okay, I will move on from there, and I want to talk about one piece of news that is not really well known, and this is maybe it's not the most critical news, but basically starting January 1st, earlier in the week, a new rule went into effect that hang on a second, I'll put it back on the screen. There we go. That the DHS can now require CBP to collect facial biometrics from all non-U.S. citizens, including Canadians and children, upon entry and departure at all ports. And this is there have been some pilot programs for this, and it's now being extended to be permanent and nationwide. So if you're traveling in and out of the country, and you see that that's happening, that's why it's happening. There's this new rule that went into effect. Okay. There was some really important news on temporary protected status this week. And I can tell you that so the news is that a judge in San Francisco issued a nationwide preliminary injunction. This was on actually was on New Year's Eve, preventing. Oh, sorry. Let me get to that headline. There we go. He issued the preliminary preventing the termination of TPS for 89,000 nationals of Honduras, Nepal, and Nicaragua. This was part of a case called Haitian Americans United Inc. versus Nome. And congrats to the lawyers on that one. But it's another example of like this on TPS, where one day you have it and one day you don't, and then the next day you have it again. And in this case, it's it's been back and forth. But that's where we are right now with respect to those countries. So if you're from one of those countries, you have your TPS status has been reinstated. There was a another piece of news that wasn't really well reported this week, but I think it's worth mentioning. And I'm just looking for the header on here. Where is it? Well, maybe I didn't put it in. But basically, there's a new public health risk bar to asylum. So effective New Year's Eve last week, there was a DHS and Department of Justice final rule that officially designates public health risks as a permanent bar to asylum. And basically, what they're doing is they are using the national security grounds for keeping somebody out of the country and applying it when they're, and basically, I had to do some looking up on what exactly they have in mind. But if there is any kind of epidemic in the home country, regardless of whether there's any indication that the person is from that area or has had any exposure or what, that can potentially be a ground for preventing them from seeking a credible fear screening and seeking entry to the U.S. As an asylee. That was sort of what they did during the COVID emergency, but now they're basically broadening that much more significantly to say that it's not just sort of these big pandemic types of things that would keep you out, but potentially any public health question that might come up, regardless of how much risk there is that the person that is here would have been exposed, or even that there was any evidence that the person was in the country when the public health emergency even started happening. It just looks like if there's a public health emergency and you're from a particular country, that it's a ground now for denying asylum. So my guess is that that's probably going to be litigated when they start to apply it to people, but that's just something to keep an eye on. All right, I want to move into some H-1B news. So one of the big stories, hang on a second, let me talk about this. So there's an H-1B rule that got finalized recently, and this was when it was published, it got a lot of publicity, but this will be part of the lottery that happens in March, unless there's litigation, which there probably will be. But for right now, the way this is going to work is you are going to be, your chances of winning the H-1B lottery are now going to be based on the wage that you're being paid. So for Department of Labor wages, there's basically 4 levels, 1, 2, 3, and 4, 1 being kind of entry level and the lower quartile, and then the second quartile, third quartile, and the highest one. So basically, the way they're going to do it is if you are in the highest quartile, you will have 4 chances in the lottery, 3 chances if you're in the third, 2 chances if you're in your second, and only 1 chance if you're in the first. So essentially, what they're trying to do is really make it difficult for people that are in entry level professional positions to be able to qualify. That sounds good from the perspective of U.S. worker jobs, but there are a lot of instances where H-1Bs are coming in for jobs that are that may be entry level, but are still pretty critical as far as needs to where there's a lack of U.S. workers. One that I can tell you that right off the bat is going to be a problem for a lot of communities is for physicians. So one thing that happens for doctors that's a little bit different than for other occupations, for specialist physicians from many locations, there are, and also some primary care, there is no prevailing wage survey that's been conducted for the place where the person is going to be coming from. So in that case, when you're seeking a wage and there's no wage that's available, the Department of Labor uses a national wage. For doctors, it's something like $115 an hour, or I think that works out to like $230,000 a year. That's that's a pretty, I mean, there's a big range of what actual salaries are, but that's the wage that they the Department of Labor is using. The problem with that is the way I'm reading the rule, and I'll be curious about what other lawyers think, but the way I'm reading the rule is that they are only going to consider that as a default wage as a level one wage for purposes of a lottery, which means that physicians, particularly physicians that are going to rural areas that are super critical, and there's no U.S. doctors oftentimes that are available to go to those areas, that those doctors are now going to be at the lowest rankings in the lottery. And it's something that Congress over the years has done, has had legislation that would have affected how the lottery happens, where people in certain people in certain categories would have had better chances, and Congress never actually passed any of that legislation. So, but doctors were oftentimes forgotten because they don't get their medical degree in the United States. They get their training in the United States, but training is not considered to be a graduate degree, even though it's called graduate medical education. So doctors would always rank like at the bottom of in those bills, and it was mostly because of ignorance, where they just didn't know that doctors even get H-1B visas, much less that they would be adversely impacted by this bill, which is mostly about raising wages for IT workers. But that's one of the risks for this, and I do think that litigation is probably going to be successful, mainly because Congress, there's all kinds of evidence that Congress didn't want to be, it didn't want this kind of ranking system for H-1Bs, and they've had a number of times where they've considered legislation to do exactly this, and they've always rejected it. So we will see what happens in the way of legislation, but keep an eye out for that. All right, let's stay on the H-1B, the H-1B subject. A lot of you are still very interested in knowing what's going to be happening with. Let me get back to it. Sorry. Wait. Why is this not coming up? Oh, okay, here we go. Sorry about that. H-1B, the H-1B $100,000 tax, which is tied to another another travel ban for H-1B workers. A lot of you want to know where that litigation is actually at. So there are 3 cases that are pending that are in some point of processing in 3 different courts. The one that's gotten a lot of publicity recently is the U.S. Chamber of Commerce case, where they filed that in the D.C. district. They had their oral arguments, and a judge has issued a decision at the district court level, Judge Howe, rejecting the chamber's efforts. The chamber, in the last week and a half, has filed an appeal to the DC Circuit, and they just got approved for an expedited schedule for briefings. Basically, the argument that they made successfully at this point is that they need to get this decided by the Court of Appeals before the H-1B lottery happens in March. So we have a deadline for the briefing schedule over the next, I think it's in early February. We don't know when oral arguments are going to happen in that case, but that's what's happening in the chamber's case. There are it's a different case than the other 2, but one of the 2 cases is the 17 states attorneys general have filed a case in Boston. That case right now, there's no news to report on that. They haven't finished their briefings yet on that case. The third case is a case I'm actually a lawyer on, which is called Global Nurse Force. And that case was filed in Northern District, California, San Francisco. So in that case, what I can tell you is that there are efforts by the Department of Justice to try and basically link our case to the chamber's case in DC. I don't think that's going to go anywhere. I think the judge in our case wants to actually hear it and make a decision for herself. But that's one thing that's happened. So we've the council have opposed that. The other thing that we do have is we actually have a date for oral arguments in our case, which is February 17th. So it's coming up in about 5 weeks, or a little bit more than that. So, the hope is in our case as well to get the decision before the H-1B lottery happens. And I remain very optimistic about the case. Like I said, they're very different. Arguments were not the same. We filed a lot of declarations. We have a lot of different types of plaintiffs than in the other case. And I think I'm more optimistic about how things are going to go. But we will, I'll keep reporting on what's happening in these other cases. And then hopefully we'll have some good news in about a month on that. Okay, what am I talking about next? The ICE, yeah. So this one is just to talk about sort of again government overreach. On Tuesday this week, there were reports that a judge has allowed the Trump administration to resume a data sharing agreement between DHS and Medicare and Medicaid. CMMS is the name of the federal agency that administers those programs. And basically now ICE is getting access to personal data, including citizenship status and immigration status, citizenship status and addresses for millions of Medicaid recipients. Normally, Medicare and Medicaid recipients are not eligible themselves for those benefits if they're out of status, but oftentimes they have children that are eligible because the children are U.S. citizens. So it's sort of a backdoor way to be able to get a lot of data on people that ICE is trying to get out of the country. Anyway, that's happened. I don't know if that's how long that's going to continue before, again, the court's trying to step in, but that happened. There was also news on the CHNV program. So that is the parole program that President Biden put in place for Cuba, Haiti, Nicaragua, and Venezuela. And basically what's happened in that program is that the administration has moved forward with terminating the program for nationals of those countries. And there's about 500,000 current beneficiaries that now face the expiration of their legal status. So that is going to throw a lot of people out of status and into presumably into a situation where they've been here less than 2 years, they might be subject to expedited removal. If they've been here longer than that, then they would be thrown into the immigration courts for removal processes. So that's where we are right now with CHNV. And then last but not least, well, I don't know why I say last but not least. It's not. Well, I guess it's a. Yeah. So this is kind of I guess par for the course again. Sorry, but let me show this. No, not the right one. Let me take that off. Basically, the Supreme Court issued a stay in this case called Nome v. Doe. And basically what they said, and this just happened 2 days ago, where they are allowing the government to proceed with the categorical parole revocations that I was just talking about, but not just for this program, but for the other ones while litigation continues. And Justice Jackson issued the dissent in that case saying that there's going to be irreparable harm to all of those people. And there's about 900,000, I think, total that are in the various programs. So CHNV is one. There's another program for Colombia and Guatemala and 2 other countries in Latin America. And then there's, of course, the Uniting for Ukraine program. So those are the stories I wanted to cover. We had some comments, and let's see. So I'll bring those up. This was a question about whether tourist visas are they okay. I'm guessing, Vikas, that you're talking about. Well, I'm not sure which story you were talking about, but probably the travel ban and so tourist visas are not okay if they're covered under a travel ban if you're in one of those 39 countries. And basically, most visa processing for those countries has come to an end. There is a national interest exception, just like there is in the H-1B case, the H-1B travel ban. But there's not much else in the way of exceptions. So by the way, national interest exceptions. I have been trying to research whether there have been any actually issued in the entire country under either the H-1B ban or the 39 country ban. And I have yet to be able to identify a single approval of a national interest exception. We're also seeing cases now where people have got requests for evidence asking for either a national interest exception or asking for them for proof of having paid the $100,000 fee for the H-1B ban. And the RFE deadlines are coming up, and people have filed for national interest exceptions, and they're all pending. Basically, there's not any movement that's happening on those. So now people are going to have to reply to a request, meet the request for evidence deadline, and just say, I applied for a national interest exception. You guys haven't gotten around to actually making a decision on it, and you've created this bind that I'm in. I don't know what's going to happen, but we're about to hit the deadlines on those cases. So starting in the next week or so, we're going to know. We're going to know in some of those cases what's happening. So Vikas had a second comment on the H-1B. This was on the H-1B lottery story that I was talking about before. But basically, physical therapists are another category where they just have a national number and they don't have they're not breaking it out by wage levels in different areas. And again, what that means is you could be paid, at the top of the scale as a physical therapist or as a physician or any of these other categories where they don't have the broken out into 4 wages, and you're going to be treated as entry level no matter how much you're being paid and how much experience your job requires, which again, I think is going to probably make for a good plaintiff, somebody in that situation when this litigation eventually happens. Okay. More questions. So Dr. Del Rosa had a question. Does that mean every J1 waiver will now go into the wage system? So let me just tell you one thing that I should have clarified at the time. The J1 waiver doctors who get waivers based on a interested government agency shortage area waiver. So that's your Conrad 30 doctors, as well as doctors getting federal waivers through Delta Regional Authority, HHS, SCRC, and those agencies. They're actually not affected by the wage rule because they are cap exempt. If you're cap exempt, this rule doesn't really matter to you because this is basically how they allocate the 65,000 H-1B visas and then the 20,000 master's cap visas, H-1B visas. But if you're cap exempt, it doesn't really matter because there's an unlimited number of those that are granted. So J1 waivers, though, that's not every J1 waiver. If you're a J1 waiver doctor who gets a waiver, for example, based on a hardship or persecution, and you're applying for an H-1B visa following that, you would have to actually get selected in the lottery, and you are affected by this. It also has an impact on doctors who are going to be abroad. No, take that. I'm sorry about that. That's not correct. So that group of doctors not affected, but the same group of doctors may also not be affected by the H-1B. They're probably not affected by this H-1B rule, and they're probably not affected immediately by the H-1B $100,000 ban either. And that's because if you're on a J-1 visa and you get a waiver and you file to change status in the United States to H-1B status after you've got a J-1 waiver to go work in a shortage area, you're not covered immediately by the travel ban. You might be covered if you travel, but you're not covered in the. But you're not affected as long as you're making that change in the United States. So that is one good piece of news for doctors in that situation. But again, there are exceptions to that. So if you are a doctor who goes abroad waiting for your waiver to be approved because it didn't get finished by June 30th when your program finished, and you haven't extended to take the boards, or the boards have already happened and then you went abroad, you're going to get hit with the H-1B ban at that point. You're also going to get hit by the H-1B ban if you're getting a waiver based on a persecution or a hardship waiver, because in those cases for an H-1B, you do have to actually travel abroad, get a visa, an H-1B visa, and come back in. And once you do that, that's when the ban kicks in. So if you're a doctor listening to this, you probably need to have a conversation with counsel to figure out what kind of waiver strategy you need to do to avoid both the 39 country ban, the H-1B ban, and then this new H-1B rule. Okay. Let's see. Question about I always hate trying to approach these questions, but basically this is questions on predictions on filing on final action dates, meeting filing dates. Is it realistic? I don't know. I sometimes say that the immigrant community is usually a better predictor than the lawyers on this, because they're actually really studying the data and the movement, and people really educate themselves about how the numbers are allocated. So is it realistic? I don't know, maybe on there, but I hesitate to make a prediction on that. Okay, you wanted me to explain why I was optimistic about the lawsuit. That the new final rule still gives level 1 wages a chance and doesn't strictly exclude any wage levels. So the reason why I'm optimistic, and I'm going to take this down because it's hiding my face, is that this is one that Congress, the statute itself doesn't give the president any ability to basically recreate it doesn't matter if they gave a chance to the lowest level wage earners. Congress set out a system for doing this, and they did not specify that all they specified was in the statute was that the person had to be paid the prevailing wage. They didn't say that there was any kind of ranking that was going to happen on cases. Congress could do it if they want to, but I don't think it really matters whether whether they've done it this way or not. This is one instance, I think, that also, I think it's important to sort of understand what the administration has going up against it. Sorry, I'm also noticing that I have the impact litigation banner on, which we did the other day. So I'm going to also change that in a minute. Here we go on that. But the other reason why I think that that it's going to be a challenge for the administration is because of the end of Chevron, which in the past the administration would have a lot more flexibility to be able to interpret a statute and issue regulations that it felt were in the spirit of the regulation. And the Supreme Court has basically said, no, it's got to actually literally be contemplated by the language of the statute. There is no indication that Congress intended for this. And in fact, the fact that Congress felt like they needed to consider bills to actually change the way they do this is an indication that Congress didn't think that the administration had the ability to do this on their own. Numerous reform packages have tried to do this proposal via legislation, which is an indication, again, that there was a thought that it needed to be done by legislation. Um, so I actually think that it's not the worst idea in the world, by the way, to do this if it's thought out well. But I think Congress needs to actually be the ones that make the decisions on it. So that's why I'm relatively optimistic that the folks that sue on this issue are probably going to be successful. But we will see. Um, and I think the administration also really rushed this out without considering most of the comments that were submitted. So we'll see. But I would expect probably in the next 2 or 3 weeks, we'll probably see litigation that's been filed on that. All right. Doesn't look like there's very many more questions, but let me see. So this is a question about the impact of the country ban. So how is it okay, no, it's not. But so this is sort of a case specific question about somebody who filed an adjustment several years ago. And sometimes what happens with retrogression or the ability to file is that so they actually do have systems in place to identify cases that, even though they have been sitting for a long time, when the priority dates become current, about flagging them and picking them up again for adjudication. And as long as you're not affected by the pause, which you haven't mentioned on here, but as long as you're not affected by the pause, it should continue to process. If you are affected by the pause, the 39 country pause, then it'll be flagged, and then it'll probably end up on somebody's desk again, but it will not be, nothing's going to happen. And then the last, we had a comment, H-1B ranking not taking regional cost of living into account. Standard pay is worth a lot more in low cost of living areas. I don't think that this ranking system took a lot of things into account. I think they were just looking for a very simple way to get the policy across, which was they were trying to encourage employers to pay level 4 wages. We will see the problem. There's a lot of problems with the wages. Some locations are very good about updating wages, and they usually reflect what current wages are. And then some places they may update them once in 10 years, and they don't reflect at all what the reality is for it. You have again where somebody may be living in one location and working remotely for somebody in another location, and the wage that applies may not be the wage that's is the one that's from a policy perspective what the administration wants. I mean, there's a lot of nuances to how the whole wage system works. So I think you make a fair point, and I'm sure that some of these issues are going to be raised in litigation. So I'm going to stop there. And I'm going to end for the evening. And I will. I know I'm going to be back next week with colleagues. Well, actually, I'm not. I'm not going to be back next week. I have a family event that's happening abroad. That's a very exciting event that I'll tell you about when I get back. But look for my colleagues to be filling in for me next week. And as usual. Thank you for joining me this evening, and stay sane. Bye-bye.